A very good evening to all of you. I, on behalf of the Indian Society of International Law, extend a warm welcome to each and everyone gathered here today, and those who have joined online also, to the fourth Justice Rajindar Sachar Memorial Lecture on Civil Liberties and the Indian Experience. The Indian Society of International Law organized these lectures in the memory of Sri Rajindar Sacharji, and the first Rajindar Sachar lecture was conducted in December 2019 on the topic Human Rights, Concerns and Challenges, delivered by Honorable Justice Madan B. Lokur. Second Justice Rajindar Sachar Memorial Lecture on Right to Food Security by Honorable Justice P.S. Narasimha. Third Justice Rajindar Sachar Memorial Lecture on Socio-Economic Rights and States Obligations by Honorable Mr. Justice S. Ravindra Bhatt. I feel privileged to extend a warm welcome to the chief guest of the event, Honorable Mr. Justice S. Muralidhar, former Chief Justice, Orissa High Court. A heartfelt gratitude to you for gracing us with your presence today, and we are truly honored to have you here to deliver fourth Justice Rajindar Sachar Memorial Lecture on Civil Liberties and the Indian Experience. It gives me It gives me immense pleasure to welcome on the dais Professor Manoj Kumar Sinha, President ISIL, Professor VG Hegde, Executive President ISIL, Dr. Srinivas Burra, Vice President ISIL, Shri Sanjay Parikh, Sir, Senior Advocate and EC Member ISIL, Shri Narinder Singh Sir, Secretary General ISIL. I would also like to welcome family of the Justice Rajindar Sacharji, his daughter Mrs. Madhvi Sacharji. Welcome, ma'am. I request Justice Muralidhar, Professor Manoj Kumar Sinha, Professor VG Hegde sir, Shri Sanjay Parikh sir, Dr. Srinivas Burra, Shri Narinder Singh sir, and also Madhvi ma'am to come on the dais and offer Pushpanjali to late Justice Rajindar Sacharji. I also welcome esteemed EC members, life members, students, and ladies and gentlemen. To begin with, I humbly request Professor Manoj Kumar Sinha sir, President ISIL, to kindly felicitate Chief Guest of the event, Honorable Mr. Justice S. Muralidhar, with a bouquet as a token of gratitude. Now I request Madhvi Sachar ma'am to come and join the dais and present latest publication of the Indian Society of International Law to Honorable Justice S. Muralidhar. Thank you, sir. Thank you, ma'am. Now I request Dr. Srinivas Pura, Vice President ISIL, to give his welcome address.
Thank you, Kanika. Good afternoon to you all. Uh, Justice S. Muralidhar, Professor Manoj Sinha, uh, Professor V.G. Hegde, Mr. Sanjay Parikh, Mr. Narinder Singh. I also acknowledge the family members of Justice Rajindar Sachar. Uh, I welcome you all on behalf of the Indian Society of International Law for the fourth Justice Rajindar Sachar Memorial Lecture. It's an honor to the Indian Society of International Law to host this annual lecture event, which is extremely an important one, especially in the name of Justice Rajendra Sachar. It is important for various reasons, but at least one or two aspects are important for even the Indian Society of International Law point of view. Human rights is the one which, of course, is one area probably it overlaps significantly between domestic law and international law. And that is one area probably the students of international law confront what happens at the international level and close relations with domestic law. Uh, it is also important to acknowledge the contributions of people like Justice Rajendra Sachar uh, because they stood for certain values. Now, these values, mostly as students of law, we try to look at it law and legal institutions. These values are not just part of the law and legal institutions, but they're also part of our social life. And people like Justice Sachar, through their professional life as well as in certain aspects in personal level, have stood for certain values. Now, these values, in general, if you look at it, goes beyond the law in political and social realm, is the questions of equality, non-discrimination, uh, like equal opportunities. So these are some of the fundamental values, irrespective of the government, irrespective of the system. Somewhere one has to comply with it. So most of the times, what happens is that when you talk in terms of human rights and civil liberties, it gets politicized, and it gets politicized always looked at from the point of view of the government, either present government or the past government. I think when we speak in terms of the human rights and civil liberties, probably the work of Justice Such's contributions on the bench as well as in his other experiences shows that somewhere I think we need to go beyond uh, the governmental system when we speak in terms of human rights. Probably we need to go back to basics of the human rights. That is, bring the state as an entity to the center of the civil rights, civil liberties debate. I think that is the most important thing. Probably we need to take note of, because most of the times, especially now, when we speak about civil liberties and human rights, it's always looked at from what the current government does, what the previous government does, that what some years ago governments do. Yes, governments do keep come and go, but state as an entity has a particular character where I think the civil liberties are essentially understood between the relation between the state and the individual as a citizen. I think that is the most central relationship, which probably, like, when you look at today's topic, that civil liberties in the Indian experience, probably the 1970s have kind of shown a significant developments in relation to civil liberties in India. Many of that is because of a few developments, which in fact emergency and others, but also equally important were certain social movements which brought the idea of civil liberties onto the agenda, and that is where the debate also took place in Indian human rights movement, the distinction between civil liberties and democratic rights, whether the civil rights have to be looked at only as a constitutionally given one, or whether the citizen has more than the law that is given to us. Now, that was a debate in 70s between civil liberties and human rights. So these are some of the central issues which, in fact, are significant. If one has to look at the understanding of civil liberties in the Indian context. And to speak on that, we probably will not get a better person than Justice Muralidhar. So therefore, I think it is important that I look forward to, and we all look forward to his thoughts on civil liberties in the Indian context. And I welcome you all again, once again, to the fourth Justice Rajindar Sachar Memorial Lecture. Thank you.
Thank you so much, sir. Now I request Professor Manoj Kumar Sinha, sir, President ISIL, to deliver his
Take this. Take this, you do.
So I request Hegde sir to come on the dais and give his address.
Uh, Thank you.
Honorable Ms. Justice S. Muralidhar and Mr. Sanjay Parikh, our President, Professor Menon, Dr. Srinivas Burra, Mr. Narinder Singh, all my colleagues and friends who have gathered here to celebrate the life and times of the Justice Sachar. And this is an annual event which we do now, thanks to the respected members of the Mr. Rajindar Sachar's family. This is the fourth lecture, already has been mentioned, and of course we know that he dealt with various issues, but most importantly, it was very close to his heart. Is the issues of civil liberties, human rights, and then some of the reports he gave, particularly on the minority status reports which he had given, is one of the most celebrated, still used, still authentic, data which has been used, and he is known. Sachar Committee report, by that name, it is well known. So besides that, his entire life and struggle, I'm sure Mr. Sanjay Parikh will elaborate more on that. But I will say two things. One of the most important issues regarding civil liberties or even relating to human rights, which as Indian Society of International Law we face as well, is the good. We have human rights treaties. Both we talk about Universal Declaration of Human Rights and sectoral treaties. So many treaties we have, but the most important dilemma and problem is the implementation of these. So as you all know, international operates at the two levels. At the one at the international level, of course, it's international law, but at the same time, at the domestic level, it has to really look for implementation. Implementation is a challenge. So over a period of time, I think last about 15, 20 years since, the countries who have become parties to these treaties, particularly human rights treaties, will have to, there is a monitoring mechanism which takes place at least now. Otherwise, we always talk human rights, though they are so basic and fundamental, included in our constitution, particularly in the fundamental rights, are core to the human values and they have to be respected. But still, I think to an extent, when human comes to human rights at the global level, for a long time it remained as a soft law. But I think now with the monitoring mechanism, some of the basic principles have become the core principles of international law and then need to be implemented. Now, how domestic legal system is going to do it is an issue which I'm sure the domestic, not only legal system, the domestic, the executive particularly, and the legislature both have to look at it as to how, what kind of implementing legislation or the implementing mechanism they are going to come up with. This is where the problem is actually, and this is the area where I think Justice Rajindar Sachar worked throughout his life. That is the key point. Actually, there is a whole device which is available, but at the basic level, it is very important for the implementation. Even today, we can see, if you open the newspaper every day, you will see that the kind of human right violations keep taking place all the time. For that, of course, we need two things. One is, of course, you have a robust institutional mechanism, which is required. Of course, the one is the court, the higher judiciary, and also the lower judiciary up to a point. But still, it's a challenge for the judiciary to actually handle these matters for various reasons. But that's why you require very robust institutional mechanism. So now the courts and also legislature actually has to debate and discuss as to how these human rights violations, etc., can be stopped at the executive level. Only when the executive fails, this happens all the time, because access to justice is not a simple task. If you think that a common man somewhere, in our own country, to have access to Supreme Court is not easy. It's not easy for even a person from a middle class to get into Supreme Court. Actually, Supreme Court is looks like an ivory tower for a person who is actually away from this place. And how do you expect the courts to actually, you know, implement human rights. Human rights are one of my. We think that human rights is exaggerating terms, but human rights are basic rights. They are not something, apart from certain sectoral rights, but human rights at the given point of time, they are most basic and they are most, to preserve the dignity of the human being. That's what exactly has to be done. So that is where I think the how to preserve the dignity and the respect and the of the human person, human being is the issue. Now it has been extended to other areas as well. So we need to look at that, and I think Justice Sachar was one of the pioneers who actually fought all his life in this area. Second, other important point in recent times is the problem which is coming up. I'm sure Justice Sachar would have actually liked it. At least in recent times, you can see that the United Nations has passed some resolution. There is a special rapporteur in relation to the human right defenders, actually. Now, how to give protection to human right defenders. Now, there are civil society organizations, like, for example, he was member and worked throughout his life on PUCL and other agencies, civil society agencies. And particularly when human rights implementation comes, state and the civil society and related other bodies actually come into different kinds of conflicts. State has the power, and state can do anything. And there is, human rights defenders, obviously not only in India, in across the world. Actually, this is the problem, including United States. So obviously, states, in order to, state is a big sovereign entity. Obviously, has to protect its. There are areas where security, territorial integrity, etc., has to be protected. Agreed, but at the same time, how to protect the basic rights of the citizens or persons who are within its territory is the key issue. Although Constitution provides in various fundamental rights, Article 21, I don't have to get into that. So but still, recently, the United Nations and other bodies have looking at the issue of protecting. At least there is no convention as yet, but there are some resolutions and reports which have come up, which is actually now looking at this kind of an idea. So I think that time, human rights defender, there should be a convention, possibly. I hope it's going to happen. It takes time for the international law to evolve. But in recent times, when you look at the human rights sort of a debate, it's not easy, actually. It's the most difficult sort of a situation, and also more difficult sort of although human rights treaties, and then you can, for implementation, you can say the states go to General Assembly every year in September, third week of September, and then heads of states make a lot of statements. These are policy statements, big statements, sustainable development goals. Then earlier you had Millennium Development Goals. All these things are good. I mean, states are hundreds of heads of states do it, but at the same time, implementation is the key in most of the domestic jurisdictions. And if you study them, I think they'll pose number of very interesting problems or difficult problems within the states. I think that's where I think the Honorable Justice Sachar and many other people like him actually have defended the values, human rights values, and related values and civil liberties, particularly in this country. So, in order to give this lecture, I don't think there can be any person better than Justice Muralidhar, because he himself, I think, pioneered and also appeared in many of these cases, not only as an advocate but also later as a judge, honorable judge. So, I think it is a fitting tribute to the great man, Justice Sachar. And with these words, I welcome him and welcome all of you to this meeting. And I hope we all can actually cherish and work towards the ideas, held close to the chest of Justice Sachar. Thank you.
Thank you, sir, for your special address, highlighting the issues related to implementation of human rights as a challenge and preserving the human dignity and also protecting the rights of human rights defenders. I request Shri Sanjay Parikh sir, EC member ISIL, to address the gathering and deliver the introductory remarks on Honorable Justice Rajindar Sachar ji.
Justice S. Muralidhar, former Chief Justice, High Court of Orissa, now Senior Advocate, Supreme Court of India. Professor Manoj Kumar Sinha, President, ISIL. Professor V.G. Hegde, Executive President, ISIL. Dr. Srinivas Burra, Vice President, ISIL. Shri Narinder Singh, Secretary General, ISIL. Madhvi ji is present here. Members of the bar, my colleagues and dear friends. We have assembled here this evening to commemorate the fourth Justice Rajindar Sachar Memorial Lecture to be delivered by Justice S. Muralidhar, former Chief Justice, High Court of Orissa, on civil liberties and the Indian experience. I welcome you all on this occasion. You have already been told that this is the fourth memorial lecture. We began in 2019. Let me thank ISIL for including Justice Memorial Lecture as a part of its regular annual event to recall Justice Sachar's contribution and commitment to the cause of human rights and civil liberties. The other annual memorial lecture ISIL holds is the V.K. Krishna Memorial Lecture to remember Shri Menon's contributions in the field of international law. Though this audience is familiar with Justice Sachar's dedication to the causes of human rights and civil liberties, which Professor V.G. Hegde and Dr. Srinivas Burra also mentioned, but it will be befitting on the occasion to remember his legacy in little detail. Justice Sachar was born in Lahore, now in Pakistan, on 22nd December 1923. His entire education, including law, took place in Lahore. Even as a student, he was attached to the national movement and had joined the Congress Social Party. His father, Shri Bhimsen Sachar, a freedom fighter, served as the first Chief Minister of Punjab after the first general elections of 1952. Later, he became Governor of Andhra Pradesh and thereafter High Commissioner for India to Sri Lanka. Shri Bhimsen Sachar also suffered detention during emergency for his staunch opposition. Justice Sachar's illustrious legal career began with his enrollment as an advocate in 1952 in Shimla. He gained prominence at the Punjab High Court and served as president of its bar association from 1967 to 1968. His judicial journey began when he was appointed as a judge of Delhi High Court on 12th of February 1970. Notably, he became the first acting Chief Justice of the Sikkim High Court from May 1975 to May 1976, immediately after its establishment. Thereafter, he was transferred to the Rajasthan High Court during emergency without his consent, before finally returning to the Delhi High Court in July 1977, from where he retired as Chief Justice in December 1985. During his tenure as a judge, he delivered many important judgments. He got international recognition when he was nominated as a member of the UN Subcommission from 1990 to 1994 on the prevention of discrimination and protection of minorities. He also worked with the UN Commission on Human Rights on the right to adequate housing and headed a mission that investigated housing rights in Kenya. Shri Sachar actively practiced as a senior advocate in the Supreme Court from 1986 till 2017. Among several important cases he argued include the cases relating to mandatory declaration of assets and criminal antecedents by the election candidates, the none of the above, nota option in elections, surveillance and phone tapping, and against the amendment in the Representation of People's Act, removing the domicile requirement in the Rajya Sabha elections. His attachment to the People's Union for Civil Liberties, PUCL, of which he was president from 1986 to 1995, was remarkable. I recall that in public functions, He always preferred to be recognized as a member of UCL rather than a former Chief Justice of Delhi High Court. In March 2005, Justice Sachar chaired a committee that came out with a seminal report after examining the socio-economic conditions of Muslims in India. In November 2006, he presented the report titled Report on Social, Economic and Educational Status of the Muslim Community in India to the then Prime Minister, Dr. Manmohan Singh. The report emphasized the systemic underrepresentation and socio-economic challenges faced by Muslim community as well as the growing social and economic insecurity and disparity. He was sought after by every human rights and social organizations to participate and present his views on the then current issues. His association with Dr. Ramanohar, Jayaprakash Narayan, and Madhu Lemay since his childhood helped him in being recognized as a champion of civil liberties. He contributed regularly on all the current social, political, and legal issues, which invariably appeared in the prominent newspapers. He passed away at the age of 94 on 20th April 2018. His son Sanjay, daughter Madhvi, and grandchildren survive him. My association with him started after his retirement in 1986. It continued for more than 3 decades till the end. We worked together on so many causes, traveled together as members of people's commissions to distant tribal areas, and fought many PUCL cases, such as on the electoral reforms and for the protection and promotion of human rights. We had discussions on various issues from politics to philosophy. One thing that I noticed during these discussions was that he would invariably mention about his father and his views. That showed the regard and respect he had for his father. Ideological. Another instance showcases his impartiality when he defended individuals against the government led by his father as the chief minister for human rights violations and arrests. See his independence. His father was chief minister. He fought against the injustices which are done. His absence is deeply felt today by everyone, particularly by those who are involved in fighting for public causes, peace, and harmony. He strongly believed in secular values and spoke fearlessly about it. Shri Soli Sorabji, while paying homage, aptly said, Justice Sachar's fight to preserve the secular fabric of India continued till the day he passed away. With this introduction of Justice Sachar, let me introduce to you this evening's esteemed speaker, Justice S. Muralidhar, currently practicing as a senior advocate in the Supreme Court. Justice Muralidhar has had a distinguished career as a lawyer and as a judge. This was evident from the heartfelt farewells he received in each high court he served and the warm receptions he was accorded upon joining new jurisdictions. He was elevated as a judge of the Delhi High Court on 29th May 2006. He was transferred as a judge of Punjab and Haryana High Court. He retired as the Chief Justice of Orissa High Court. As a lawyer, before being elevated as a judge, he was intensely involved in significant cases, including the Narmada Bachao Andolan, Bhopal gas tragedy, the defense of prisoners on death row, etc. He was also the Standing Counsel for Election Commission of India and the National Human Rights Commission for several years. As a judge, his contributions have made an indelible impact, not just on the judicial side, but also on the administration of the court system. Notably, in 2009, he was part of the division bench that decriminalized consensual homosexual acts between adults in the Nas Foundation case. The following year, in 2010, he ruled in Sudama Singh case, holding that the government's decision to deny resettlement of Juggi inhabitations as illegal and unconstitutional. In 2018, he authored a significant judgment in the Hashimpura case, convicting 16 Uttar Pradesh provincial armed constabulary PSC personnel for their involvement in 1987 Hashimpura massacre. Same year, he authored Gautam Navlakha case, quashing the transit warrant issued by the magistrate for the arrest of Gautam Navlakha by the Maharashtra police in Bhima Koregaon case. He authored the judgment that reversed the acquittal of Sajjan Kumar for his role in 1984 Sikh massacre, categorizing such acts as crimes against humanity. As the Chief Justice of Orissa High Court, he introduced several initiatives, including the establishment of paperless courts, digitization of case records, e-filing systems, e-libraries and a warrant management system, and a dedicated PIL portal, leaving a lasting impact on the administration of justice. As lawyers, we appear together in many human rights issues. His unflinching commitment to civil liberties and human rights has continued throughout his legal career till date. More than that, a captivating smile on his face reflects the richness of his inner being. The subject for today's discussion is not only relevant but extremely important. History tells us that the people of this country have risen together whenever civil liberties have faced threats. Indian experience has taken shape around Gandhiji's idea of non-violence and insistence on truth. It has guided us in every difficult situation. We have inherited peaceful protests from our forefathers and freedom fighters. But things have become complicated now. The communal divide is disturbing the constitutional fabric. It is affecting human values, fraternity, and dignity. What should be done at this juncture, based on the Indian experience, is what we will be hearing from our esteemed speaker today. Thank you.
Thank you so much, sir, for highlighting and making us aware of the contributions made by Justice Rajindar Sachar for the promotion and protection of human rights. Now, I request and I feel privileged to take this opportunity to invite Honorable Mr. Justice S. Muralidhar, former Chief Justice Orissa High Court, to deliver 4th Justice Rajindar Sachar Memorial Lecture on Civil Liberties and the Indian Experience.
Good evening, everyone. Dr. Srinivas, Burra, Professor Hegde, Sanjay, Professor Sinha, and Dr. Narinder Singh, Ms. Margi Sachar, all the members of the distinguished audience. To be asked to speak in the memory of someone you idolize is itself a big honor. And when I joined the bar here, Justice Sachar had already returned to practice. And seeing this diminutive figure with a clear, strong voice and an erect back, if anyone has seen Justice Sachar, posture was absolutely erect, but it symbolized who the man was and never feared anyone, never afraid of power, never wilted. He had a bad day in court, and there was Sanjay would testify this. There were many bad days in court because difficult cases were being handled by Justice Sachar. But his conviction, his courage, it's remarkable. So for lawyers like me who just joined the bar, it was a very, very big inspiration. I don't know, in myriad ways, Justice Sachar influenced some of us and reminded us that we need to keep going despite a bad day in court. So Justice Sachar is someone I really looked up to. And when I read his autobiography, it moved me so much. The man was so rich with his experience and yet so down to earth and so warm and compassionate. Just look at the photograph in front of you and look at the eyes. It tells you who the man was. That was his compassion, and it's as if he's here with us with that same smile. I often wonder what Justice Sachar would say if he were around now. He would definitely urge all of us to pull up our socks and keep going. That was him. Undauntable spirit, a person who exuded energy. I think many of you were not fortunate, but we were extremely fortunate to be in the presence of such a personality. When he exuded positivity all around him. And that's the memory that stays with many of us and keeps us going. So I was wondering how should I peg this lecture and what should I start with. When fortunately for me, I came across this judgment of the Bombay High Court delivered on 6th December 2024. 6th December is infamous for several things, but there is a positive judgment of the Bombay High Court exactly 1 week earlier. And this judgment is delivered by a bench of Justice Sonak and Justice Jitendra Jain, a division bench of the Bombay High Court, in a petition filed by the Manvi Hakka Sanrakshan and Jagrati. What is interesting about this judgment is that it struck down a circular issued way back in July 2018 by the Charity Commissioner, Maharashtra State, Mumbai. And you wouldn't believe it, but I'm going to read it very carefully. That circular directs notices to be issued to the trustees of the trusts, which use the phrases Bhraštachar Nirmulan Mahasangh, Bhraštachar Virodi Andolan, Bhraštachar Mukt Bharat, or human rights in the title of the trust name, and further directs them to remove the same. So basically, what the circular does is you can't even use the expression human rights in the name of your trust. You can't use the expression Bhraštachar Nirmulan Mahasangh. You can't use the word Bhraštachar Virodi Andolan. And what is the justification for this kind of a strange circular? It is that there are many organizations who are impersonating, and this is exact words from the judgment, they're impersonating as if they have the powers of the state to deal with corruption and human rights. So instead of dealing with that problem, they decided that they will change the way the organizations describe themselves and say human rights is a word that we will not permit. So this is 2024, and it required a division bench, the Bombay High Court, to remind the Maharashtra government on a very technical point that they did not have the powers under that Maharashtra Charitable Trust Act to issue such a direction. So, and of course, they had to put in various caveats saying, yes, if organizations are misusing such name and doping people, of course, you have to take action against them. But that would not justify issuing a circular that says that no such name, no such words should be used. And that brings me to another aspect of what we are faced with today, and which was foretold so well by George Orwell in the famous novel 1984, where it reminds us of a big brother watching all the activities of the people of the state. George Orwell interestingly spoke in that novel of what was called thought crime. That is a state with whom you do not agree will try and repress, suppress any idea or thought. You don't have to translate that into action. They fear your thought. So they actually developed what was called newspeak. This is a fictional narration in that novel. But what is remarkable is how George Orwell conceptualized it. They have a new language called newspeak, where the number of words is limited, where the grammar is structured so that nothing sounds negative. And you can't explain anything in long sentences. You have to do it in very short sentences. And certain words are simply erased from the dictionary. There is a word called black white. And what is it? Black white is accepting whatever one is told, regardless of the facts. In the novel, it is described as to say the black is white when the party says so, and to believe that black is white, and more, know that black is white, and to forget that one has ever believed to the contrary. There is another word called crime thing. Thoughts and concepts that go against the establishment, such as liberty, equality, and privacy, and also the criminal act of holding such thoughts, frequently referred to by the standard English thought crime. What is thought crime? Personal beliefs that are contrary to the accepted norms of society. And there's two very interesting words coined by Orwell. One was mini love. Mini love is the ministry of love. What does the ministry of love do? This is the ministry where the secret police interrogate and torture the enemies of the state and the indulge in brainwashing. And there's something called the mini truth, ministry of truth.
which manufactures consent by way of lies, propaganda, distorted historical records, while supplying the proletariat with synthetic culture and entertainment. So, some of you in the audience will understand why it is relevant to read 1984, why it is constantly important to remind ourselves that if we don't exercise our freedoms of thought, of expression, they can easily get killed. Imagine a whole generation of young students today in several states in the country reading that on 30th January 1948, Mahatma Gandhi was only killed and nothing more. And some school textbooks go further and say that he died on 30th April 1948. Now, this is the extent of historical distortion. Whatever happened in Haldigati, what happened elsewhere. So we are now in a state, in a stage in this country's history where a very conscious attempt is being made to control thought, which is why stand-up comedians, sarcasm, humor, taking pot shots at famous personalities, all this is viewed very differently. They don't hesitate to book a case for hurting the feelings. You know, the number of FIRs that are filed for hurting somebody's feelings. This was not there even 20 years ago. So there is a very conscious attempt to suppress one of the fundamental freedoms that one would expect in a democracy governed by the rule of law, which is the freedom of thought and expression. And that's why I thought this judgment of the Bombay High Court should actually be publicized, should be discussed and spoken about. Because interestingly, that judgment quotes the circular of the Maharashtra Charity Commissioner, who in turn refers to some judgment of a Madras High Court where a similar circular was upheld under the Societies Registration Act. It is a serious assault on civil liberties if you're allowing the state curtail even the expression, using the expression human rights. So that brings me to where we are and why we are where we are. I want to refer to three publications that have been placed in the public domain. One is the Human Development Report for 2023-24, and it's titled Managing Interdependence in a Polarized World. All of you should know that the Human Development Index measures human development by analyzing the country's performance in three dimensions: health, education, and standard of living. You know, normally when we talk of GDP, it's all in terms of economics, per capita income, what is the wealth generated by the country through its goods and services that it produces. And economists, including our own Amartya Sen, have long been critical of this kind of an approach to describing what is the progress of a country. So the Human Development Index gives you the other way of looking at progress and asks, how is the country faring in terms of health, education, standard of living? So the health dimension is assessed by life expectancy at birth. The education dimension is measured by the mean of years of schooling for adults aged 25 years and more, and expected years of schooling for children of school entering age. The standard of living dimension is measured by gross national income per capita. In 2022, India's rank was 134 out of 191 countries. It was far below Russia, China, Sri Lanka, Bhutan, South Africa, Philippines, who all fall in the high HD countries group. It is even below Bhutan and Bangladesh in the medium countries, medium range developed countries. Among the countries in the South Asian subcontinent, only Nepal, Pakistan, and Afghanistan are below India. What is interesting is this report notes that 1 in 5 children globally lives in or is fleeing conflict. Millions of people, including children who have been forced to flee their homes due to no fault of their own, could not live a life of dignity. And it speaks of a global trend, and this is, I think, very important for us. It talks of an emerging democracy paradox. 9 in 10 people believe that democracy is a fundamental pillar of political systems, but they, at the same time, support leaders who bypass the fundamental rules of the democratic process And more than half of those polled expressed support for such leaders. So if you go around the world looking at Turkey, looking at Hungary, looking at Russia or China, looking all around us, we find leaders who are by their very nature dictatorial, having popular support and getting elected through the electoral process. So this is the disturbing trend that this report talks of. The second important report that we need to look at is the Social Progress Index. And this again is something that is published year after year. And this report asks three questions. Does a country provide for its people's most essential needs? Second, are the building blocks in place for individuals and communities to enhance and sustain well being? And three, is there opportunity for all individuals to reach their full potential? So, in terms of the Social Progress Index in 2024, India would rank only 111 out of 170 countries with an overall score of 58.06. It had slipped four ranks from where it stood last year. Child stunting, sanitation, hygiene, press freedom are all areas in which India has taken a beating. The last report I'd like to refer to, generally I would say last but one, is the World Happiness Report. India again ranked 126 out of 140 countries behind Libya, Iraq, Palestine, and Niger. Older adults with secondary or higher education and those of the dominant social castes report higher life satisfaction than their counterparts without formal education and those from the scheduled castes and scheduled tribes. The last report I would like to refer to is the Freedom in the World report of 2024. And there it notes that in just 2023, political rights and civil liberties were diminished in 52 countries, while only 21 countries made improvements. One major reason was flawed elections and increase in armed conflict. Manipulation of elections, this report points out, was one of the leading causes for the global decline in freedom in 2023, driving down the scores in 26 countries. Not only was electoral manipulation widespread, but it also took on a wide array of forms. Among these forms in which you manipulate elections is attempting to alter the outcome of an election after voting has taken place. And this report rightly notes discredits the democratic process by underscoring that voters do not, in fact, have a say in who governs them. Many of us in this audience will identify many of these problems that is now emerging worldwide. It's not peculiar to India, but it is a problem that we have to contend with. And that is what brings me to the importance of the civil society groups which are engaged in India for many, many decades now in defending our civil liberties. I want to start a bit earlier than the emergency, although we'd like to believe that the real activity around civil liberties among civil society groups took place around the emergency. No doubt the excesses of the emergency was a major catalyst in this direction. But our civil society activities date back more than a century. In the 19th century, we've had many social reform movements that responded to caste and class inequalities. This included the Brahmo Samaj and its offshoot, the Arya Samaj movement, later the Theosophical Society, with the object of resisting and demanding abolition of child marriages. Recall the work of Rajaram Mohan Roy. These movements built the momentum resulting in a law abolishing child marriages being passed in 1929. In the pre-independence era, we saw Vaikom Satyagraha, led by Sri Narayana Guru in Kerala, E.V. Ramaswamy Periyar, and the Mahad Satyagraha, led by Baba Saheb Ambedkar, which led to the passing of a law permitting temple entry to all castes. We saw political movements like the Champaran movement, the civil disobedience movement, the Salt Satyagraha, with all led by Mahatma Gandhi, which had a deep impact on raising social consciousness and catalyzing the growth of the freedom struggle. On a lighter note, I think if Mahatma Gandhi were to apply for permission to the police commissioner in Delhi asking for a march, he would be stopped right out at the border somewhere beyond Noida or Ghaziabad and not allowed to enter. These movements also inspired struggles for freedom elsewhere in the world. Many of these movements had an impact on how laws were made, enforced, and how courts decided cases. After independence, we had the launch of the Bhudan and Gramdan movements of Acharya Vinoba Bhave, in which many participated and donated large tracts of land with the above object of redistribution among the landless. This inspired a whole set of land form laws. Then we had peasant movements, we've had Dalit movements, we had women's movements, we had environment protection movements like the Chipko movement by Sundarlal Bahuguna, the movement to save trees, the movement of the backward classes, and the backlash to those movements in the form of the anti-Mandal agitation. All of this have shaped the laws and policies of reservations, had a telling influence on the approach of the judiciary to issues of quotas in education government jobs. The movements of the past have inspired the events of the present. Tribal revolt led by Birsa Munda in Jharkhand and the Telangana movement of the late 1940s were the inspiration for the formation of the separate states of Jharkhand in 2000 and Telangana in 2014. As I was examining what is it that civil society liberties groups have been doing, I paused to see that there is a group called the Association for Protection of Democratic Rights. It's based in West Bengal, and it's been in place since 1972. And this was the time when there was a disillusionment, if you remember, the origins of the Naxal movement and how it began in West Bengal. And this group is active today in protesting against police excesses and excess of repression and suppression. Then we've had, of course, the PUCL. Among the founders of the PUCL was Jayaprakash Narayan, Krishna Kant. They were all associated, and Justice Tarkunde. Justice Tarkunde, who also practiced as a senior lawyer in the Supreme Court for many years, was among the founding pillars of the People's Unions for Civil Liberties. Sanjay has referred to many of the PILs filed by PUCL and continue to be filed by PUCL. And I would add to the list that you mentioned, Sanjay, the right to food PIL by the PUCL, which is still in court. And that inspired and compelled, in a sense, the parliament first to enact the Right to Food Security Act. Then we've had PUDR, the People's Union for Democratic Rights. What is remarkable about both PUCL and PUDR is they are totally crowd-funded. They made the policy not to accept funds from donors outside of India or even groups within India. Because even within India, we have large corporate donors. But neither PUCL nor PUDR, and I stand corrected if I'm not saying the right thing, as far as I know, don't accept funds from any donor organizations. And they generate their whatever minimal funds to the reports of the fact finding they conduct and the reports they otherwise publish.
Individual contributions.
Individual contributions. Then we have Common Cause. Hegde Shri, Arun Shri's father, who was a retired bureaucrat, started this Common Cause. And again, I think it was not funded by anyone as far as I remember. And on very meager funds and shoestring budgets, I think Sanjay has handled many cases for them. I have handled many cases for them. And a very modest office and working selflessly day and night. That was Mr. Hegde Shri. Then we have the Environment Legal, India Environment Legal Forum, Action Forum. Then we have, of course, the Narmada Bachao Andolan. Both Sanjay and have handled cases for them. I've handled cases for the Bhopal groups, the Bhopal gas victims groups for many, many years. And I've now come back to, again, doing cases for them. And then we have the National Association of People's Movements, NAPM. And I've also been fortunate to be able to fight cases for the Safai Karamchari Andolan. You'll all recall that we've had a legislation abolishing dry latrines way back in 1993. But like so many legislations, they never got implemented. So in village after village, town after town in India, you'd always find dry latrines and you'd find managed scavengers employed to clean dry latrines. So this litigation, which was as a 32 petition in the Supreme Court, and I would call it as a class action litigation because apart from the Safai Karamchari Andolan, we had individual sanitation workers also as co-petitioners with the Safai Karamchari Andolan. It was a totally researched petition where we gathered facts, photographs, videographs from all over the country. And we were shocked to see that there's not a single state in the country which did not have dry latrines and did not have sanitation workers cleaning them. and a majority of those sanitation workers were women. So this litigation culminated in a positive judgment of giving compensation to those who die cleaning sewers, who die doing sanitation work. A lot needs to be done in terms of rehabilitation of those who are weaned away from sanitation work. And we have the National Campaign for Dignity of Sewer Workers. The work done by these campaigns and the petitions filed by them and argued before the court have led down to positive changes in the law. Then we have in the environmental field, Goa Foundation. We have the Andhra Pradesh Civil Liberties Committee, which did remarkable work in terms of negotiating between the People's War Group and the government of Andhra Pradesh. And they believed in peace and non-violence. They believed in truth and reconciliation. And that is what is remarkable about civil society groups. Most of their approaches have been Gandhian. They're always peaceful, non-violent, and Gandhian. And they work with people and among people. And that is what appeals to many a youth in the universities, and that's how they form their early politics in life. So it will be a pity if groups like this are attacked by the state as being anti national. It would be very unfortunate for this country if we do not allow a kind of accountability to be demanded from the state by the activities of these groups. Then we have Voices Against 377 because they were petitioners before the court. We have the NAS Foundation, and we have many groups working among transgenders, and they're doing human service. Many of these groups don't have too much publicity. They're not in the public eye. They're not publishing glossy reports, but they're doing selfless work day after day. And I think we should admire their courage, their persistence, and their competence in being able to handle issues which they are faced with. And they always find themselves answerable to the people, accountable to the people. So when you look at the social movements, the civil society movements, and you ask yourself, what has been the relevance of having these movements? One is they've learned to engage with the state, engage with society, and engage at bringing about positive changes. They do it in a variety of forms. For instance, we know how to use the right to information legislation. Many of them you will find that go on, asking questions of departments, of ministries, collating that information, sharing that information, filing petitions on the basis of that information. It's all very tough work. It's all requires a lot of patience, it requires a lot of diligence, and many of them are at it. And it helps all of us when the positive changes happen in the law. If you look at some of the slew of legislations that came out between the years 2004 and 2014, what straightaway comes to mind is statutes that operationalize the right to livelihood, the Manrega Act, statute that operationalized the right to food, the Food Security Act, the Right to Information Act, the Forest Rights Act, the new version of the Land Acquisition Act, the 2013 law. What is remarkable about the 2013 law, it first of all frontally acknowledges the phenomenon of internal displacement as a result of projects. But for, and I would with Sanjay here, make bold to say that, but for the repeated agitation and keeping in the public domain the problems faced by those displaced with the dams in Narmada and displacement elsewhere. I was Chief Justice of Orissa, and I still had petitions coming up before me complaining of non-receipt of compensation for acquisitions for the Hirakud Dam. You look at the Nagarjuna Sagar Dam in Andhra Pradesh, you will still have petitions in the Telangana High Court saying that compensation is yet to be paid for farmers. So this is a story across India. And because of the presence of these civil society movements, these people's movements, I think the parliament was forced to acknowledge, and therefore in the 2013 legislation, we have something called a social audit. The social assessment report has become a very important component. Now, earlier, these reports were being prepared by a PUDR or a PUCL or by a People's Tribunal's report. Sanjay has been part of so many of those People's Tribunals. Justice Sachar has been part of so many of those People's Tribunals. They would produce the reports. They would have what we call the subaltern versions, the voices. People would come speak in their own language before a distinguished panel. Panel would prepare a report. Very often, it happens in this country, the report would be published. presented at a press conference and then kept for the state, waiting for the state to react to it, which may never happen. But in this period, one saw some positive changes in the law, and somewhere people were made the center of these laws. I could also think of the India Against Corruption movement, which was led by Anna Hazare, but which of course got captured. I'll come to that in a minute. It got captured, and poor Anna Hazare, I think, felt very disillusioned at the end of all of this. What that movement produced was the Lokpal law. And we all are able to see in the last 10 years how that law has really been deprived of any strength. So I'm just saying that these are all what I would call the bottom up approaches to lawmaking. So civil society groups have played a very, very important role in this bottom up approach to lawmaking. And this is something that we need to acknowledge and therefore need to persist with these kinds of efforts and not get disillusioned because of what we find is happening around us in the present. I would also like to now dwell on what Professor Gargalala terms as the deliberative democratic practice. So, what really happens when these groups go to the court is that state brings out information which otherwise it would not part with. And a kind of a dialogue is fostered in the court, with one position being taken by the civil society actors, one position being taken by the state, and the facilitator being the court. So there is a democratic space that is created where a dialogue can be fostered if the court encourages it. And that is a very, very important process. Very often, when we file these PILs, and I'm sure Sanjay also advises his clients, we tell them that this is one more element in your struggle for securing rights for your constituency. It is neither the beginning nor the end. But what purpose it serves is it brings out the positions of the relative actors, facts which otherwise would not be easily accessible, and the attitudes that are out on display. So that deliberative democratic practice is actually played out in some of the PILs that are brought forth to the court by the civil society organizations. And therefore, you have a slew of cases that have been fought in the Supreme Court and the High Courts by these organizations for the people that have helped in bring out more information and greater accountability and transparency than we would have expected of the state otherwise. Because state is always reluctant in opening up its files, its records. We know what is happening with the RTI Act, but this is a fight that must be carried on because we have to, utilize whatever tools we may have to their full potential. I also now want to dwell on the kinds of repression that are being faced by the groups in India today. It's multifold. One is because many of these groups cannot function without some kind of funding, and many of them have received funds from foreign donors. One way to curtail their activities is to cancel their FCRA registrations and licenses. And this is happening in thousands. I must point out that this is not that the present regime is doing it and the earlier regime did not. In fact, this, using the FCRA law to deny registrations and licenses started in the UPA regime itself. And it has only been continued in the present day regime. And I must share with all of you that the state as an entity behaves in a very predictable kind of way. If the state is asked to be accountable and answerable, the state will resist. So I'm talking of cases that I have against the left front government in West Bengal, which had a very bad track record of human rights violations. You had horrible cases of deaths in police custody, violence in police custody, and this is where the left front was in power in West Bengal. Look at Kerala now. There have been cases registered because somebody had an adverse Facebook comment against the chief minister there. Mamata Banerjee, any comment made adversely anywhere can invite it. So across the political spectrum, you find that anyone demanding answerability and accountability will find state against them either in terms of criminal law action or inquiries or searches and seizures or raids. So one is the FCRA track where you cut out, you close the tap, as they would say, because all these groups are now very conveniently bracketed as anti-national. They are part of a Tukde guy, or they're part of some, left liberal. So all these have become, which is why that newspeak becomes very important. Today, the word human rights. So if you have a human rights organization, they may deny you a visa. If you're attending a human rights conference, they may deny you a visa. So I'm just saying that there are countries, not just India, even countries abroad, that have become hypersensitive and nervous about all these being talked about in public and a public opinion being generated around it. Then you have taxation laws being used. Many of these groups have income tax raids, reopening of assessments. So they're running around in circles between the tax department, between the police, between the ED, between the CBI. So there is a there's a targeting of many of these groups through various forms. And among the youth, and this is something that Justice Sachar would definitely not approve. If you read his autobiography, you could see how a fiery student leader he was. And many of the leaders we see, including the prime minister we have, they would not have emerged as leaders had they not been student leaders. They were very active in their student days in politics. Jetli was a very prominent student leader. Sushma Swaraj was. Lalu Prasad was. Ravi Shankar Prasad was. I'm just saying, name any of the prominent politicians that you can recall. They all emerged from student politics in universities. And today, the first clampdown is on universities. And it's not just about the JNU, but universities across India. Today there is an atmosphere of fear, of being not able to speak up, and inviting criminal law action if you even held a protest. So 144 is quite liberally used in many of our universities and campuses. And this is something that should cause us concern. Because if you're going to have a whole generation of youth who have not been introduced to politics, then how do we expect democratic practices to flourish? How do we expect to create an environment in which we can practice democracy, ask for accountability, vote sensibly? Unless you're able to vote sensibly, you will not be able to elect people, elect leaders who will then be answerable to the public. So, across political spectrum, and I don't single out any political formation, I'm including the present government in Delhi now, which doesn't hesitate in getting onto certain platforms just to capture votes. And this is something that is played out right in front of our eyes. And it's very sad spectacle to see that they start off with very high ideals and then become something else. So this is the nature of the political process that we have. This is the nature of the state, which is why it is important for youth and for the groups now working in civil society organizations to engage with the youth, to tell them that this is India's history, this is India's past. These are the leaders that emerged from these movements, and they may have morphed into something else today, but this is where they started. And why it is important, therefore, to practice democracy at that grassroots level, at the student level. Only then we can have people who nurture constitutional values and definitely of freedom of speech and expression, of thought, of association, of assembly. You list out all those freedoms, it will be meaningless if you do not give space for it and allow democracy to flourish. So, what would I expect civil society groups to do? One is for us to remain transparent. When we demand transparency of others, we must be transparent in our practices ourselves. When we demand, to know how monies were received, how monies were spent, we must endeavor to do it ourselves. So we must practice that level of transparency and accountability ourselves. How do we engage with opponents? Very often, when we organize meetings, we will call people who are like-minded. And today, there's a reason for that. You have a meeting organized, you have a fear of somebody coming and disrupting the meeting. But that should not deter you from engaging with your opponents. And which are the examples you look at? You look at Mahatma Gandhi. The way he engaged with his opponents, I don't think anyone had more opposition than he did. The same forces today that are celebrating Nathuram Godse were very much there during Mahatma Gandhi's time, but he knew how to engage with them. We need to take on the difficult task of engaging with our opponents, compelling them to a civil debate. We can't run away from it. Gandhi never ran away from it. And that's why he became what he was, and his values still endure. Then we need to be in with the people. What I find with some of our groups is that they don't consult the constituency that they're appearing for in courts. They don't take back to the people the strategies that they're planning in court. So the people get left out and they find that they did not agree to a certain course of action. So this way of engaging with the people on a constant basis, speaking the language of the people, that is very important. Like we generate a lot of reports, right? How many of those reports are explained back to the people from whom these reports were generated? How many of those reports are placed in the public domain? How many of those reports are shared amongst each other? So these are the healthy practices as civil society organizations we need to develop: sharing of information, putting that information in public domain, sharing of reports, and collaborating with each other. We should not become in competition with each other. As long as the competition is healthy, it's fine. If the competition is going to be mutually destructive, it should be avoided. I'm talking typically of PR space being used by people with opposing public interests. The environmental group opposed to the right to shelter group. This is a very typical kind of one group against the other that gets played out in the courts and which can easily be avoided. So I think we also hold a mirror to ourselves and ask what are the ways in which we can strengthen the work, where we can inspire the next generation to do better and to keep the focus on protecting democratic values and constitutional values. We must practice these values at our personal level. We must firmly believe in those values. Only then will be able to inspire. And this is all should not be measured in terms of success and failure. This is a very convenient binary which we should avoid. We should build on the efforts of the past and make sure we step one step at a time further towards the goal of total freedom, total liberty, and total equality. So with that, I think I've covered most of what I wanted to say. Just wanted to end with this poem of Faiz Ahmed Faiz. All of you, of course, have heard it so often. हम देखेंगे वो दिन जिसका वादा है जो लोहे अजल में लिखा है देखेंगे जब जुल्म सितम के कोई गरा रूई की तरह उठ जाएंगे महकुमों के पांव तले ये धरती धड़ धड़ धड़केगी और एले हकम के सर ऊपर जब बिजली कर कर कड़केगी हम देखेंगे थैंक यू
Many thanks, sir, for enlightening the gathering with your remarkable lecture. We all are grateful to hear in-depth insights on the topic by Justice Muralidhar. Thank you once again. Now I invite Professor Manoj Kumar Sinha to deliver presentation.
Thank you very much, Kanika. Honorable Justice S. Muralidhar sir, Professor V.G. Hegde, Shri Parveen Parikh ji, Shri Sanjay Parikh, Shri Narinder Singh ji, Dr. Sunil U.C. Jha, M.K. Rao sir, and all my colleagues, students, and of course, Madhvi Sachar ma'am. So after hearing Lordship, I have very few words to add, but I will certainly add something which we should add because you have written and that is the obligation we have to take for you. लेकिन आपका बहुत बहुत आभार कि आपने मैं आई वाज जस्ट थिंकिंग कि हिंदी में बोलूं कुछ बातें लेकिन मैंने सोची कि थोड़ी सी तो लेकिन मैं कल ही ट्रम्प को देख रहा था टेलीविजन पे सो व्हाट आई नोटिस्ड आई डोंट नो वेदर आई लाइक और डिसलाइक ट्रम्प बट व्हाट आई नोटिस the way they are warm and the way they like तो वो थोड़ी-सी कमी हो रही है यहाँ पर, तो मैं सारे श्रोतागण से अनुरोध करूँगा कि हमारे आदरणीय जस्टिस मुरलीधर सर के लिए, उनके भाषण के लिए जोरदार तालियों से उनका my association with Honorable Justice Rajindar Sachar sir, it was just a dream. Like when I came to know Sanjay sir in 1998, and then one day he said, "Okay, I'll take you to the Justice Rajindar Sachar's home. Madam, I have been to your places. I had been to your places many times." And I remember how, like, a young student, he motivated. Like, he said, "Kare, Manoj, ye karna hai, wo karna hai." And every time, whenever he calls Sanjay sir, Manoj ko bhi leke aana. And I remember a long time back in 2007 or 2008, Italian delegates came, and they were that particular time working for the moratorium for the death penalty. They said, "Ki if Indian government doesn't want, it's perfectly fine, but we can have something moratorium, like, and in that connection, that meeting took place in your home, and we were there. So a lot of and then whenever sir needs some kind of assistance for articles and everything, that's the first thing used to come to me. So I learned many things from sir, and that is how I'm very happy that Indian Society of International Law, we started during the Parikh sir's time memorial lecture, and that is continuing to happen every day. Uh, Another important point which I have and which I wanted, because we are very late, the international organizations, particularly even the International Criminal Court, International Court of Justice, when it comes to the define and use the term and make the person uh, accused for the genocide, they are very reluctant. And that goes even till today when the international arrest warrant has been issued. So they mix up with the crimes against humanity and they go for the softer and genocide. But you had enough courage in one of the occasion, then you have equated more or less. So they struggle to find doulas specialists, like, aggravated intention or something. And so, like, somewhere politically the decisions are taken at the global level, and they are reluctant to use the genocide. But we are very happy that our judge, Justice Muralidhar, in one of the case almost is to that particular level. The point which I have in my mind today to share, and that is very important, your interpretation and application of the citizens unamended citizenship amendment act 1987, when how this case became a landmark case, and I keep on citing. I wrote paper on refugee law also. There are two cases which your judgment was followed by the Karnataka High Court also, given Tibetans to right to vote, that was applied by the, and I urge the young students, a decision, if I remember correctly, that was given in 2010 in Nomgyal Dolgar versus Ministry of External Affairs. And the Ministry of External Affairs was reluctant to grant the passport because she had put nationality as Indian column. And then you said, ki unamended Citizenship Act will be applied because she was born on the 13th April 1987. And that is the application. That is very landmark case, and I request all of those who have interest. And wherever I go, I cite that particular case now. So there are a lot of things, and then also Lordship has written extensively on the socio-economic rights, right? And that is the way. So we are very fortunate that Lordship you came today, and just like after 3 days of the Universal Declaration of Human Rights, which talks about the slogan for this year, our rights, our future, right now. That is the slogan, and focus was on the preventative, protective, and transformative is there. I'm sure your critical lecture or talk today will motivate many young students and all of us to see that things, how we have to fight, how we have to struggle to protect the rights, protect the liberties, and both domestically. When we talk about the human rights, we confine, and that is, I have a question: okay, human rights is truly universal or human rights is local? Because when we talk about the human rights, we think about our own perspective, and we tend to forget what is happening next door. We say, this is the matter domestically for the other state. So some way human rights concept for the political leaders, for us also, it's remains confined to the territorial boundary. And on other hand, we talk about the nature of the human rights as universal. So this dilemma has to be addressed effectively, and I hope like people like you and others will take it further in there. With this, I thank everyone for coming here, and I think yeah. Thank you very much, Lord, Sir, for coming and everything.
Much, sir. Now I request Narinder Singh sir to propose formal vote of thanks.
Yeah, recently also I read in the arrest warrant has been issued like and they have like always.
Honorable Justice Muralidhar, Dr. Manoj Sinha, Mr. Praveen Parikh, other distinguished members of the society on the dais and off the dais, distinguished participants, ladies and gentlemen. I thank Professor Justice Muralidhar for the scintillating lecture he has given us on civil liberties and the Indian experience. He has highlighted the work of several organizations in the field of human rights. And he has shown that it is the small steps which are important. Every organization which he mentioned worked in a specified field, and in that area, they were able to achieve results. So I think this is a very important lesson for us. While we can talk of universal human rights, etc., we have to go down to the grassroots level and see what is actually needed by the common man, by the persons who are the most underprivileged in society, and to see how we can make their life better, how we can improve their situation. And I thank Justice Muralidhar for highlighting this aspect of the implementation and the enhancement of human rights. I also thank all the participants who have come here to take part in this event, all the students, all our members of the Indian Society of International Law, and other delegates. And with this, I just end my vote of thanks, and I thank you once again to everyone, and again to Justice Muralidhar for accepting our invitation, especially at very short notice. And with this, before concluding, I would like to invite everyone for tea, which is served on the second floor. Thank you.